call the meeting to order and ask the clerk to call the roll.
Dr. Lee,
Here.
Ms. Shinholster,
Here.
Mr. Reynolds,
Here.
Mr. Mullins,
Here.
Mr. Chambers.
Here.
We have a quorum. I'll ask everyone, if you will, to please stand for the prayer and the pledge. Our most kind and gracious Heavenly Father, we thank you for this day. We meet to serve our community, to use our resources wisely and well. We respect all members of our community fairly to make decisions that promote the common good. We recognize our responsibilities in the past and in the future, Lord. Be with us and help us and guide us as we do this. Help us to conduct this meeting tonight in a way that will be pleasing unto you. I pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You have all received copies of the minutes of May the 26th council meeting and the June 1st council meeting that was a called meeting. Do I hear any corrections? Hearing none, I'll ask for a motion to adopt.
So moved.
Second.
I have a motion and a second. I'll ask the clerk to call the roll.
Dr. Lee,
Aye.
Ms. Shinholster,
Aye.
Mr. Reynolds,
Aye.
Mr. Mullins,
Aye.
Mr. Chambers.
Aye.
That passes. The next item on the agenda was under old business, and I am going to ask for a motion to remove that from the agenda concerning the adoption of the budget. We had a work session starting at 5:30 today. We did not complete the discussion of the budget, so we are going to set a work session for Tuesday, June the 16th at 5:30. Do I hear a motion to remove this ordinance 1505-011?
I make a motion that we remove this agenda item pending further discussion. Second.
I have a motion and a second. Is there any discussion on that?
Do we need to set a date for the actual budget though? That was for the call meeting, right?
This is a work
The
session.
work session.
Mhm.
What about the actual adopting?
Well, the
Would be at the next meeting.
Yeah, the city manager will be responsible for putting that back
On the agenda.
for the June 23rd meeting
Okay.
and for the advertising.
Okay, I know we need to advertise, put it on. Okay.
Madam Mayor, one correction on that. The city manager asked us to meet at 5:15.
To meet at 5:15. Okay. 5:15. We will meet Tuesday, June the 16th. Okay, and I have a motion and a second that we do this, so I'm going to ask the clerk to call the roll.
Dr. Lee,
Aye.
Ms. Shinholster,
Aye.
Mr. Reynolds,
Aye.
Mr. Mullins,
Aye.
Mr. Chambers.
Aye.
And that passes also. I'll move to new business and ask the clerk to read Resolution 1506-027 by caption.
To authorize a resolution to amend Resolution R-1503-012 adopted on March 24, 2015, giving support for RST Champion Creek LP by changing Champion Creek to Mallard Lakes with the same intent for the development of 64 affordable rental housing units on Meadow Ridge Circle to be named Champion Creek, with their express intent to apply to the Georgia Department of Community Affairs for 2015 competitive housing tax credits for the financing.
You have heard this resolution. Is there anyone that would like to have anything to say about it on council? If not, I'll ask for a motion.
So moved.
Second.
I have a motion and a second. I'll ask the clerk to call the roll.
Dr. Lee,
Aye.
Ms. Shinholster,
Aye.
Mr. Reynolds,
Aye.
Mr. Mullins,
Aye.
Mr. Chambers.
Aye.
And that passes also. I will ask the clerk to read Resolution 1506-028 by caption.
To authorize a memorandum of understanding between the City of Milledgeville and the Attorney General stipulating a violation of the Open Meetings Act and stipulating to assure future compliance with the Act.
I will recognize William Nolan, if he will, to please come to the podium and explain this resolution.
Thank you, Ms. Walden. Good evening, everyone. I won't spend, of course, I'll answer any questions the council has, but I don't intend to spend a great deal of time. I know we've talked about this in great length at prior meetings. After the last meeting, the council authorized Mr. Jordan and I to meet with the Attorney General's office, which we did, and thanks to a great deal of assistance from Mr. Jordan, we were able to arrive at a proposed memorandum of understanding for this body to consider that I think more reflects the facts and what happened than the previous version did. And again, a lot of that was due to Mr. Jordan simply being able to explain a lot of things in the way they happened. And what we ended up with, I'll just go through point by point, and I'm going to go past all the whereases in the beginning and just start with the numbered paragraphs beginning on page 3. The first really bears no discussion. That was the March 3rd, 2014 meeting that took place after a public meeting. And again, as before, the Attorney General put in paragraph number 2 that it was not indicative of a pattern, but that it was a violation, which we all knew and we all said all along. The next paragraph deals with the meeting to discuss amending the ethics ordinance. You all recall that when Mr. Richardson was here. The Attorney General has taken the position that that was a violation. And in this document, we are agreeing that that was a violation. Now, what the Attorney General agreed to do after we explained everything, what the Attorney General agreed to do was to include as an exhibit, and you'll note that it's Exhibit D and it comes first but that was because this was the last thing that was done. So rather than re-letter all the exhibits, the Attorney General's office simply put D as the first exhibit. And what it says now is that the council had retained special counsel, an attorney, for the purpose of doing this. Council was advised by the attorney to handle it in closed session, and that's why it happened, and allowed Mr. Richardson's letter to the Attorney General explaining that, and he disagrees with it, and his explanation for why he advised the closed meeting is attached and made part of this, and I think you've all seen it. That was important to me, and I think to Mr. Jordan, simply because we wanted it known that you all did not just by yourselves decide to go into that meeting. Obviously, anytime you go into a closed session, you do it upon advice of counsel, and that's included in there. The SPLOST dispute with the county was part of the last one, and the sewer rate discussion, all the meetings in regard to disputes with the county were prominently featured in the last memorandum of understanding draft. They are in this one as well, but I think what you'll find here as we read this is that it talks about what the Attorney General previously alleged in regard to these meetings. Had previously alleged that they were held illegally because there was not a potential litigation at that time, something rising to the level the Open Meetings Act allowed to close a meeting. Mr. Jarrett and Mr. Jordan were able to produce documentation showing that in fact there were disputes rising to that level in place. So what has been done, they were left in, but it says that it was a previous allegation and that we were able to provide evidence that it was in fact appropriate, and so that covers 4 and 5. So there was no violation found for either of those things. The number 6 is an agenda issue, and you'll recall in the last time I was here, there was the allegation that agendas were being or items to be voted on were being included at the very last minute. I told you all then, and I'll tell you now, I didn't find evidence of that. And so, and the Attorney General's office agreed to put in that we disputed that allegation. But then, of course, right on May 2nd, there was the issue, I believe it was a retreat, and so that was included. It's certainly not a major violation, but the way that happens a violation, so this document agrees to that. And the Attorney General, suggested, but it was probably a little stronger than that, that we agree that we will post our agendas 7 days prior to meetings. And that's not required specifically by the law. There is no time requirement. In fact, I think anyone, including the Attorney General's office, would agree that the 4 days we've been doing is I believe is the week before. 4 days that we've been doing is legal. Okay, so that's not what this is about. This adds 3 more days to what you have been doing, and hopefully it won't materially affect negatively how you all do business. It's a concession that the Attorney General's office has asked for. Now, that does not mean that all the materials that are to accompany the agenda, all the things, I don't know if you all use binders or how you use it, but all of the things have to be with it. Just the agenda with the topics will be posted a week before the meeting. And I don't believe I've missed anything. I think the rest simply says, and the fine was lowered to $2,500. Obviously, we would prefer not to be fined at all, but there were a couple of violations that were found. And it is my recommendation to the council that this memorandum of understanding be approved, that there be an authorization for it to be signed. I think it would put to rest what has been a lengthy and unpleasant investigation and the process. I think ultimately this document is fair. I think the Attorney General's office has been fair throughout the process, and we got to the right place, even though it took longer than I would have liked, and I'm sure that everyone in this room would have liked. So if there are any questions, I'll be more than happy to answer.
Mr. Noland, about 2 months ago, I believe was the last time that you were before this council, and a citizen asked a question regarding the cost of legal defense fees during the ethics hearing. We last saw that was somewhere in the neighborhood of around $57,000. You also represented Mr. Jarrett and several other members of council during the ethics case. Were those invoices sent to the city for payment, or were those invoiced to those individual defendants at the time?
To the city.
To the city.
Yes, sir.
I would like to address Attorney Jordan on this. Attorney Jordan, you said at the time when the question was brought up as to whether or not the city would appropriately be paying for this, or whether it would go to those individual members, that would be up to this body. Has this body had time to discuss and determine whether or not those fees should be applied to those defendants or to the taxpayers?
No, that is not what I said. What I said at the time that question was posed to me was that in the past ethics investigation that I had advised Mr. Joyner that the city would not be paying for it, reimbursement for the expenses. As you'll know, subsequently, there was located a resolution, I think, passed and adopted in the Griffin administration that authorizes defense reimbursement. If you'll recall, without getting into the substance of the closed meetings, that Mr. Richardson discussed that with you, and actually I provided you with a copy of that. And so any payments or reimbursements being made would be made under that defense reimbursement policy. It was a policy that I was not privy to because it was adopted before I came back on board with the city, and because of our not having the codification that we have in process now, it took some research, but I believe one of our council members actually, I can't remember who it was, brought it to my attention that they thought they recalled during the Griffin administration that being adopted. So clearly the reimbursements, the payments would need to be in compliance with that reimbursement policy. Y'all were given an opinion by Mr. Richardson that clearly this would come under that defense reimbursement policy.
And if I may, for the benefit of the council, I don't believe my bill was $56,000. I think that may be the total.
This is, I guess, sort of a question. A lot of people complain now, even with the 4 days that we have, when things come up and things arise or things happen in the community, that they're not allowed to be a part of the agenda because the agenda was already set and placed out. So then making it 7 days, I just want to make sure that the community understands that, you know, when we say, well, you know, the agenda's already set for the next meeting and we can't put you on the agenda, and then it's going to be 3 or 4 weeks later when it's maybe not such a big deal, that the citizens do understand that that's what we're being required to do.
Yes, and I agree. I think there's kind of two sides to it in other counties and cities that I've represented. It in some ways it does inconvenience people who want to be on the agenda. On the other hand, it could be looked at that it puts rules in place so that there's not this kind of squishy. That's not a very professional word to use, but this kind of where everybody's trying to, well, I want to be on the agenda, and there'll just be a rule, you know. And there are, let me say, and Mr. Jordan can advise you as to when this is appropriate. The law does allow for an agenda to be amended under certain circumstances. It's just not supposed to be a practice that is done regularly, and it's supposed to be for a reason that is compelling. Things come up, and the agenda laws in the Open Meetings Act are somewhat vague as far as what they require, and
Sure.
They don't have. It'd be nice if it said in there 7 days or 5 days. That may cause issues of holding people's feet to the fire to a particular deadline, but everybody would know what the rule was. And I think it can be good and bad, and I suppose we'll find out as we go through. And if it's, I'm sure we'll find out soon whether it's a hardship on Mr. Jarrett and Mr. Denuser to do their part, and for everyone to get things on the agenda. It was. Ultimately, the Attorney General was reasonable with us, and it was a concession that they asked for and seemed as though it was going to insist upon, and I think it may turn out to be a good thing once everybody gets used to it.
Ms. Shinholster, if I could speak to your concern about allowing individuals on the agenda given the additional days that the agenda would need to be posted. I think that this council could certainly take up a policy similar to our peers in the county, and that is to build in a section at the end of the agenda that would allow for public input without it necessarily being a part of the process for them to contact Bo and be placed on the agenda. If we opened up a spot at the end of each meeting for public comment, then that would alleviate a lot of those issues, and that's something that I would like to see this council consider moving forward.
That's a good idea, but I'm really not thinking about that. I'm thinking about the last minute grants, the last minute this, the last minute that. That basically we were not habitual changers of the agenda. We have never been that. We all of us have understood when the agenda needed to be in, when it needed to be out, when items need to be listed. So that was not something that we were habitually doing. I have complained along with Ms. Walden and others about last minute things coming up. And coming to the meeting and being changed, and it was not necessarily citizens, but it was grants and things like that. So I'm just wanting to make sure that people understand that can't be done.
And I've seen that in other places
longer.
many times. People come up in the day before a public meeting, and well, we have to get this approved now, or else we're not going to get money. And there are, and sometimes those are the types of situations where you can amend the agenda to accommodate that, but I completely understand the point.
Does council have any further questions? You got any? Okay, with no further questions, you've heard the resolution. Is there a motion to adopt?
I make a motion that we adopt the resolution.
Second.
I have a motion and a second. I'll ask the clerk to call the roll.
Dr. Lee,
Aye.
Ms. Shinholster,
Aye.
Mr. Reynolds,
Aye.
Mr. Mullins,
Aye.
Mr. Chambers.
Aye.
That passes. We have one reappointment, tonight. That's fine.
I'd be happy to.
That's fine.
Thank you.
We have one reappointment to make tonight, and I'm nominating John Alton for reappointment to the Main Street Downtown Development Authority Board. Do I hear a motion to confirm this nomination?
So moved.
Second.
I have a motion and a second. I'll ask the clerk to call the roll.
Dr. Lee, Ms. Shinholster,
Aye.
Mr. Reynolds,
Aye.
Mr. Mullins,
Aye.
Mr. Chambers.
Aye.
That passes. If there's no further business, I'll ask for a motion to adjourn.
So moved.
Second.